In today's video, we're going to talk about part 2 of the top 6 myths about revocable living trusts. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. Also, before we get going, a couple caveats. First, this is not legal advice. These videos are for educational purposes only. And secondly, we're going to be primarily talking about Minnesota law here. So if you live in another jurisdiction, make sure to talk to an estate planning professional in that jurisdiction to answer your questions. With that said, let's get going into the top 4, 5, and 6 myths of revocable living trusts, and starting with myth number 4. Revocable living trusts protect assets from creditors. This is not true. When you have a revocable living trust, again, if you've seen any of my other videos, it's creating a legal fiction where you create a box, you put your stuff in the box, and your box owns the stuff. But you own the box, therefore you pretty much own the stuff in the box except for probate purposes. Now, because you own everything in the box and the trust is amendable by you, it offers zero protection for creditors. If you wanted to have creditor protection, you have to create an irrevocable trust, put your assets in an irrevocable trust, and then the creditors cannot access it. The problem is you can't access your assets either, so you probably don't want to do this. However, if you are giving money in a will or a trust and you make a testamentary trust for, say, one of your children who might have creditor problems, you could make the testamentary trust irrevocable and just have it pay out them money over time, and that would protect them from creditors. But a revocable living trust alone is not going to do the trick. Myth number 5, revocable living trusts are inexpensive. This may or may not be true, and I'll just say it's not always true. Very simply, if you have to get a lawyer involved, then it's not going to be inexpensive. My apologies to all the lawyers out there, but not really. When you are doing a will, you of course have to pick up probate fees, and this will be filing fees, this will be publication fees, and if you have to do hearings, you'll have to bring in an attorney. If you do a trust, you don't have to pick up these probate fees, and you may be able to do everything without an attorney. However, if it's a complicated estate, or if someone challenges the estate, you're going to need to bring in an attorney. I just spoke with someone who, when they administered their estate, it cost them $60,000 for an estate that was worth only $2.something million. That's a lot of money, and in that case, once you challenge a trust, you end up in front of a judge, and you're going to need to get an attorney anyways. So just because you have a revocable living trust doesn't mean you're going to save money. In many cases, they will, but in some cases, they don't. Myth number 6, and the last myth that we're going to touch on today, is that assets are available immediately upon death in every revocable living trust, and this is just not true. In a will, before you can access the assets, first you have to get your petition to probate the estate, or probate the will, and to be appointed personal representative approved. Then you have to probate the will and be appointed, and then there has to be a 4-month creditor notice period before you can generally do a full payout of all the assets. In a trust, under Minnesota Statute 505C.0605B, it states, upon the death of the settlor of a trust that was revocable at the settlor's death, the trustee may proceed to distribute the trust property in accordance with the terms of the trust. So under statute, you can immediately give out money from the estate. However, estates that are managed by a trust are still subject to creditors' claims. So if there's a question as to whether the estate is insolvent or not, or whether how much money is owed to a creditor, the trustee is going to want to hold back certain monies to make sure that they're covered, because if they pay out an early distribution or an improper distribution, they may be personally liable. Also, there's other expenses of the estate that needs to be paid out before distribution, such as funeral expenses, administration, etc. So there's a lot of reasons that a trustee might want to delay money. Also, I'll say that in a will, you can get an early distribution. There are in a couple ways. One is there are exempt assets, such as a family allowance, that allow the personal representative to immediately pay money out, regardless of what creditor claims there are on the estate. And that can be done very, very early in the probate process. Secondly, a personal representative can do an early distribution of the assets, but again, they may have to get a court to allow them to do it if it's in a formal probate. If it's an informal probate, you won't have to get a court approval of it because it's not supervised, but the personal representative still may be personally liable if they improperly distribute assets early. So there's risks with both. Yes, it is more likely to get assets early in a trust, but not necessarily so. So there you have it, part 2 of the top 6 myths of revocable living trusts. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. It really helps support the channel, especially the subscription. I need to get to 100 subscribers for the algorithms to pick me up. So every subscriber is appreciated. If you did like today's video and you're looking for further videos, we do a new video every other Wednesday, so you can look forward to that. We've got some interesting topics coming up. Other than that, if you have questions, leave them in the comments below or send me an email. My email will pop up at the end of the video. And until next time, this is Gregory Singleton with Signature Law.